Good morning. Thank you all for coming. I'm Leanne Luttrell DiLorenzo with VoteERA.org, and our purpose here today is to talk about the Equal Rights Amendment Bill. We have two of them. SJR 24 is our bill in the Senate, and HJR 21 is our same bill in the House of Representatives. And with me today are some of our sponsors. We've got Representative Debbie Boone here, Representative Wally Hicks, and Representative Julie Parrish, and we are very thankful for them for coming. I should mention that before I get into sort of the nuts and bolts on the Equal Rights Amendment, that we have 50 sponsors, and they are bipartisan sponsors on both of these bills. And I have to say, after working in Oregon politics for a very, very long time, that is something that we find quite meaningful. When I was walking around the building asking legislators, would you please consider sponsoring these bills, not one hesitated. And that point leads me to the other aspect of this process that we've been engaged in, and that is that we took a statewide poll through Public Polling Policy. They're nationally known. They've ran a lot of public polling for other campaigns throughout the state of Oregon. And as somebody that's been focusing on the academia of the ERA for a decade, informally and formally for about 4 years, I knew that the numbers would be very high because the bills that we have are in fact the language of the classic Equal Rights Amendment. And that language has been around since 1923 for the federal ERA. We really hoped to have a high number of Oregon voters in support of this, but we were astounded that 80% of Oregon voters found men and women to be equal, which was of course nice, but also that they found it important enough to have it stated in the Oregon Constitution. And so with that, I have to say, it seems the question would next be is, this is a no-brainer. Why are we here talking to you today? There are obviously many, many important issues that the legislators have going on. Public safety, PERS reform, the general budget. And I can tell you, as a citizen lobbyist, they're working very hard and very well together on all of these issues. What we find is that equality for women is a thread through all of those issues. For example, part of the Democrat platform is to help middle-class families, and to the tune that the ERA can provide women's equality, whether it be in equal pay or even symbolically. We don't believe that that just helps women. We believe that that helps the whole family. And so to get to a little bit of the nuts and bolts of the ERA, people often get the state ERA confused with the federal ERA. So I do want to start and say that from 1923, when the federal Equal Rights Amendment was first introduced, it was only passed through Congress one time in the 70s. We are now in the 90th year of it still being introduced every year in Congress. So there is no federal ERA. And one thing that was mentioned by Supreme Court Justice Scalia just a few months ago was the United States Constitution does not say you have to discriminate against women, but it doesn't say it prevents it either. And so with that, I looked to the Oregon Constitution and found that, of course, there is no ERA. So the next question is, what does the Oregon Constitution have that protects equality for all? What we have is something called Article 1, Section 20. It was written in 1857, ratified in 1859. It has never prevented discrimination against women, which brings us to the point of the Hewitt versus Safe Oregon Supreme Court case from 1982, when the very courageous Justice Betty Roberts provided the court opinion and basically elevated the judicial review for women, referring to them as inherently suspect, which provided then a higher protection of judicial review for women. Many people felt that that was an ERA, and we would like to honor her effort, but at the same time acknowledge that that is not still having the ERA directly expressed in the Oregon Constitution. which is why we have SJR 24 and HJR 21. What we are trying to do is to prevent any inroads from being carved into Hewitt versus Safe. For example, cases are often reinterpreted. We have the consideration of future judges, and cases are overturned. An example is Stranahan versus Fred Meyer. That's an example of a Supreme Court case being overturned. If that were to happen, regardless of the slim chance that that could happen, women would then be back to being represented under Article 1, Section 20. So this is a little bit of the last piece, if you will. And so we do feel it's very important. We feel that the fact that it is a bipartisan effort is also critical. Some of our challenges, which is part of the reason we are here today, is that, again, we have not had a hearing. We have no promise of a hearing or a work session. This is concerning. And the reason it's concerning is that there is sort of a notion that there are some historical keepers of the ERA. And what we believe is that we are waiting for many people to join us, but also that it isn't about us, that it's about the generations and generations of girls to come that don't have to continue this century-long effort in having your equality expressed in the Constitution. And so we have had one group that has been direct, which is always appreciative of their concerns, and that is the ACLU. And they had a concern that other groups' rights would be lost. And so although we believe the ERA is a separate amendment, and we've had great legal counsel on that, as a good faith effort to try to address their issues, we have an amendment, -1, which basically says just that. This will not in any way alter, change, infringe upon anyone else's rights under Article 1, Section 20. Another concern was that the ERA wasn't needed. So let's look at that. What we can say is that if somebody says in Hewitt versus Safe, providing the highest level of judicial review is the same as if there were a federal ERA, that can't be a true statement because, A, there is no federal ERA, and again, it's not in the Constitution. And so what I would like to ask is, think of the other protections that are afforded us in the Constitution. Why do we hold those so dear? Because that is the highest level of protection of our rights. So as I come today, there's two questions that are often asked, and they are acceptable questions. And I would like to challenge anybody with regard to thinking about the ERA also in a different way. And that is, why should there be two sides to the ERA other than within the political process? How can there be two sides to women having expressed constitutional equality? I don't see that there are two sides. I see that there's a lot of politics. The next challenge is, why do we allow people to say, is it practical or just symbolic? And the best response we have for that is, isn't having your equality directly expressed in the Constitution practical enough? Isn't that in itself practical? There are many other issues regarding race and all sorts of other equality issues that are very symbolic to other groups. The Equal Rights Amendment is no different. So with that, I leave the question for women's groups that have been around for a long time to please join us. From the 1994 ballot measure 7, there was actually a statement from women's groups, the League of Women Voters, Jewish Federation of Portland, National Organization of Women, Right to Privacy, National Council of Jewish Women, Oregon Women's Political Caucus, and the ACLU. They were actually opposed to Measure 7 in 1994, and this is why. It says, the Federal Equal Rights Amendment proposed for the U.S. Constitution would provide greater protection for women, meaning they wanted to use the same language that we have here today. They say, but Measure 7 doesn't look anything like the federal ERA. The federal ERA stated, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That was specific to women and didn't supersede existing protections for other citizens as Measure 7 could do. So we have that language. That is what these bills are. So I hope that we can move through politics and the process. It's obvious that Oregonian voters, they want the Equal Rights Amendment. 75% of them agreed with the classic language. Another 67% said that even if a court case provided equality for women, they still felt it essential to have it written in the Constitution. And probably the last nugget of what we learned about the public view on the ERA is that we asked the question, if the ERA were on the 2014 ballot, would you be more likely to vote? 53% of people said yes. And this is across both parties. So again, we're not looking for this to be a political tool. We feel that the bipartisanship is critical. It's wonderful. It's what Oregon is. And so I will leave you with that. And thank you. And I'll come back for questions once our representatives have a chance to discuss this as well. Representative Boone?
Yes, as the senior member of this group, I will take that. So it was 43 years ago in 1969 in Hansey Hall, University of Washington, that we formed the first women's liberation group because of the inequities in the laws at the time. And I worked throughout my college career. I watched this thing start and stop several times, both federal and state, and then I gave up until now. Last year, I saw Stephanie Kuntz from Seattle and in Astoria at a Columbia Forum, and she talked about some marriage equality things. I saw Gloria Steinem last year at a Planned Parenthood event, and this just re-energized me because both of them said, go for it, do it. And I said, well, I can't do this myself. So when I came down here and Leanne came to me and asked me to sign on to these bills, I was stunned and very re-energized by that. So this time, the time seems right, and as before, we're doing it for our daughters and our granddaughters and all the generations to come, and our sons and our grandsons, too. So this is an equal rights amendment. It's the same 24 words that we have been working on all this time. I would love to see it in the federal Constitution as well, but this is, as a state-by-state effort, I think this is a good time to do this, and I hope that we can gain the support, get a hearing, a work session, and get this out as a referral to the voters. Thank you.
Representative Hicks?
Thank you. I am proud to come from Josephine County, which is named after an early pioneer, a working woman who helped to found that portion of Oregon. And even today, we see working women bringing this amendment before you and demonstrating how essential they have been to our state's prosperity since the beginning. This measure should have been included in the Constitution originally. It's 153 years overdue, and I am confident in the public's appetite for passing such a measure if they're given the opportunity to decide on it. Measure 78 in the election of in the general election of 2012 passed with more yes votes than any other ballot measure of that cycle. That measure, among other things, allowed the Secretary of State to be a woman for the first time in our state's constitutional history. And this measure is, I think, going even further in a much needed direction. So I strongly support this effort, and thank you for coming out today to cover this.
Well, I appreciate you being out, Representative Julie Parrish from West Lynn. You know, my mom's family came to this state before it was a state, and the women who settled Oregon had a lot of grit. We recognized that when Oregon passed the right to vote for women years before that right was given in our federal Constitution. I think this is another example of where we can be ahead of the federal Constitution, since they weren't able to get that done in the 70s. And as you know, as a child who was born in that era, you know, we grew up, women under 40 grew up with this notion that we could do anything, we could be anything, and I think to not have that memorialized in our Constitution is a shame. But I don't have girls, I have 3 boys. And I feel that my obligation to raise my sons is to raise them in a world where they understand that women can do anything, women can be anything, and that the girl sitting next to you in your classroom is your equal, and she is your peer, and she could be your business partner, she could be your wife, she might be your boss. And to honor that and respect that, I feel my job as a mother raising boys is to raise men that respect women. And so helping this along is just one more way that I can show my boys that it's important to respect and honor women. And so I'm glad to be a part of this. You know, this is, Leanne brought up a great point. This is not a Republican issue or a Democratic issue. Dwight Eisenhower, as our president, really sponsored and supported and wanted to see this in the Constitution as a Republican. It was in the Republican platform for years. So this is not a new thing to our party, and I think it is time to work with our colleagues across the aisle and move this bill forward. So thank you for being out here today, and we look forward to the conversation on the House floor when the resolution comes. Thank you.
Thank you. Are there any questions?
I had a question for
Peter.
any of the representatives
Yes.
about if this were in effect today, are there any pieces of legislation that it would have an effect on, or whether there would be legislation you would propose that would be held constitutional because this would be in effect?
Would you like me to address that?
Is there would there be a practical effect on the lawmaking of today if this were in effect?
The practical question. The best answer is that a great example is equal pay. And a particular government official, when I asked him if the ERA would help him with protection of discrimination cases, his answer was absolutely. I don't know that that would then make payouts. I don't believe it would. Would it afford a higher level of review? I believe that is yes.
You mentioned a ballot measure in 1994.
Yes.
Have there been any occasions since then? I mean, has this been introduced in previous sessions but not had a hearing? Or, I mean, what has happened between 1994 and 2013?
Well, actually, so in 1973, Oregon's always been a leader on the ERA, maybe even without realizing it. Oregon was the only state in the nation to ratify the ERA twice. One of my projects in studying the federal ERA, which has been my focus for a very long time, was to discover that. So I've actually gone through all the testimony in the state of Oregon, and I don't believe there has been another effort since 1994. And I will leave it with that. I don't believe so.
Process question, where has HJR 21 been assigned?
HJR 21 has been assigned to Representative Tomei's committee, Health and Housing. And historically, an ERA has been assigned to Rules or Judiciary, typically. But
So I just want to get maybe a simplified,
yes,
take that, 10 minutes at your beginning.
Yes.
Pare it down to what do you want? You're going to put a ERA amendment in the Constitution. Is it already written? What do you want exactly specifically?
right. What we want is an amendment in the Constitution that says this: equality of rights under the law shall not be denied or abridged by the state of Oregon or by any political subdivision in this state on account of sex. So you will notice there's no word in here that says women. It is really, from the beginning, if you will, whether your box is checked male or female, to make sure that both have equal representation that is directly expressed in the Oregon Constitution.
Can I just add, Senator Knope has a different bill, but again, another kind of cleanup of our Constitution. The language in the Constitution refers to the governor as he. I'm surprised that our first and only female governor didn't fix that when she was in office. But if Boone or I wanted to run for governor, we would be referred to in our Constitution as he. And so there is an opportunity in this session to really look at just the cleanup of our Constitution, make sure that women are protected in it in multiple ways, and this is a good first step for that.
You're not announcing any.
I'm not announcing, no, and I offered up Brett Boone for governor, so as well. But just the notion that we would have women not acknowledged in that way in our Constitution, again, there's two opportunities to fix that this session.
The symbolism matters. Yes.
Particular, I mean, you said that nothing's been scheduled. Are you hearing that nothing is going to be scheduled? Are you hearing resistance to the idea of getting this through the committee process to the floor for a vote?
Well, you know, we are mid-session, and we have 50 legislators in a bipartisan fashion that have sponsored this bill. We have a poll that's been released that actually shows that this would pass the Oregon voters by a 59-point margin. So yes, there seems to be some resistance. It seems to be sort of filled with a little bit of the history I've been reading about the last century of the federal ERA. Quite often, if somebody is not an attorney, they're in a very vulnerable position to argue the Equal Rights Amendment when somebody is saying there are legal concerns and leaving it as such. So what we are trying to do is to push this through process, politics, and refocus the Equal Rights Amendment in Oregon on the issue based on facts and evidence.
Thank you.
So, thank you very much.